to the Gilgo story, and joining us live, Andrew Lieb, attorney at Lieb Law in Smithtown, Long Island. So, Andrew, we were talking about the DNA, and the prosecutor is wanting to make the point that a cheek swab from Rex Heuermann, they say, matches hair on the victim. What is the defense likely to say about that?
Well, the defense already did say that they haven't had a chance to analyze the results. This is a DNA sample, and it's very problematic for the defense because, hey, we had this pizza box that was linking to the victim before, but now this cheek swab says that the pizza box is actually the suspect's DNA. So this is a big problem. But when you deal with defenses, to answer your question, you go through and see, did they do anything improper with testing? Is there any problems here along the way? Is there issues with the evidence? Is there issues with procedure? That's what they do.
And could you also say, it could match other things?
100%. You see, when you're dealing with criminal defense, your goal is not to show innocence. Your goal is to show that they can't prove guilt. So you don't need to show you're innocent. You need to show doubt. You need to sow doubt. You need to show it's not beyond a reasonable doubt. So you point to everything and confuse everyone and make it impossible for someone to say it's a slam dunk against you.
Let's talk about discovery. And Andrew, if you would explain that process for us. Sophia was reporting that thousands of pages were given to the defense. How does that work?
The DA Santamartino actually said he gave 5,000 pieces of evidence so far. That's what he told the judge. And the way it works is when you're a criminal defendant, you have full rights to all the evidence that's going to be used against you. And right now, what's going on in the process is the criminal defendants team gets to see all the evidence. Why? Because perhaps if you know you're dead to rights, you will take a plea. Maybe you'll want to go and say, I want to challenge this evidence. To give you an example, maybe they got evidence without a warrant, without probable cause. Maybe they used that evidence to find other evidence. That's called fruit of the poisonous tree. We need to test the evidence because the judicial process is such that you can object with writing, with substance, with analysis, and you don't have to always be on the spot in court. In fact, there's a way that they can come in and say, we want to block everything through a motion. It's called the in limine motion from ever getting introduced in court whatsoever. This is the motion practice we're at now. And
the defense has a lot, as you point out, to go through. So much so, I mean, we're talking 13 years this case has been going on. So when, Andrew, could this possibly go to trial?
Unfortunately, a defense doesn't have unlimited time. We're going pretty fast on how this is going to go on. You have to fund and have enough people to be able to do this in the defense. But I often like to tell clients, they say, how long is this going to take? And I say, you don't need to know law. Just how long would it take you to read something that's 5,000 pages and study it and analyze it? This is going to take forever. But at the end of the day, again, they better drink a lot of espresso because the judge is going to get impatient fast.
Interesting. All right. Always great to have you here. We thank you for your insights and your legal expertise. Andrew Lieb, attorney at Lieb at Law in Smithtown, Long Island. WCBS News Time, 11:48.